to is your contact center compliant? Answers to your TCPA compliance questions. All lines will be placed on mute to prevent any background noise. Thank you. Henry Dancer, you can begin the webinar.
Thank you very much, Darshay. So I'd like to welcome everyone to the session today. My name is Henry Dancer, and as you can see from the slide, I'm the VP of Sales for the Western region for Noble Systems. I'm in Southern California. Been in the contact center space for about 30 years, and I will be moderating our session today. So before we get going, I want a couple of, I always use the term housekeeping items, I guess. As Darshay mentioned, everybody will be in muted mode. This is actually the third session we've had here on compliance, TCPA, and whatnot. We had 2 last year, and we will have another one in a few weeks, so keep a lookout on your emails for that. And it's going to be very similar to our previous sessions, where we kind of go through question and answer sessions with our experts. And if you don't catch all the answers, don't worry. We're all going to be posting this on the Noble website in just a few days. It takes a couple days for us to get it all edited up and put together, so give us a couple days on that. And then whatever questions we don't get to, because obviously we have a finite amount of time, we will follow those up and put them on the website as well. So hopefully you'll get everything you need out of this, and if not, we can check the website over the next few days. So let me introduce who we have on the panel today. So my partner in crime, Ray Barada. Ray, why don't you say hi so people can hear the voice and maybe give a few-minute description of yourself.
Well, hello, everyone. My name is Ray Barada, Strategic Solutions Director here at Noble Systems. I'm based in Northeast Florida. I have about 20 years experience in the outbound contact center marketplace, including serving on both the manufacturing and operations side of the house, with a heavy concentration on telesales, collections, and compliance. My role today is to add practical context as to examples of how Noble's approach to working in the TCPA environment works. And I'm looking forward to hearing what the responses are to the questions you guys have put out there. Thanks, Henry.
Thank you, Ray. So now our featured guest, shall we say, is David Kaminsky. So some of you who have been on previous webinars may have heard David speak before, but for those of you who are not, let me give you a brief background on David. So David Kaminsky is a partner at the law firm of Carlson & Messer, a defense firm which focuses its practice in creditors' rights and financial services litigation. For the past 15 years, Mr. Kaminsky has represented banks, credit unions, collection agencies, and the telecom and teleservicing industries in claims brought under the Fair Debt Collection Practices Act, the Fair Credit Reporting Act, the Telephone Consumer Protection Act, and related state and federal consumer protection statutes. He's a recognized leader. He's recognized authority and speaker on such topics. He also serves as outside counsel to both banks, collection agencies, and teleservicing industry, and has developed policies, procedures, and compliance training programs to minimize their risks of liability. He has successfully represented clients in courts throughout the United States and has extensive experience in multi-district and class action litigation. He also regularly defends clients in investigations and proceedings initiated by Consumer Financial Protection Bureau, Federal Trade Commission, Federal Communications Commission, and other federal and state and regulatory agencies. So David, welcome, and maybe you could speak for a few, anything else I might have missed that would be good for the team to hear. David,
thank you. Thank you so much for that introduction, and I think everyone has heard more than they probably need to hear about me, but thank you so much. And I do provide, I am a defense litigator, and I do provide a tremendous amount of work for the trade industries because I feel that as a practitioner, it is so important. There is no level playing field with regard to so many of these statutes, the FDCPA, the FCRA, the consumer statutes in the states, as well as the TCPA. I feel that it's my duty and obligation as a practitioner to provide advice and consultation and to do what I can to help the industry to make significant change to level the playing field in these areas of the law.
Great. Thank you. All right, Ray, you want to move forward? You can go to the next question. So yeah, so we're going to be, all right, so David, we received a lot of questions from the attendees today, and really how to stay compliant with the new TCPA regulations, especially in modern society where many people no longer have landlines. So I think in the beginning we're going to go through some of the questions, and then we're going to go through some of the best practices after that. So something you want to say here on the general review of the TCPA law and how the regulations affect the various industries?
Sure. So just briefly, as you all know, what is the TCPA again? It regulates calls to wireless devices, and really the crux of this is the wireless device ban. There is a part of it that does regulate landlines as well, and we'll get into that in a second. So very quickly, just as a recap, and I know many of you know this, so we'll go through this quickly, that the TCPA on the wireless side, on the cell phone side, basically prevents a call other than an emergency call. And believe me, I know everybody on this phone, I would agree with you that collecting your debt is probably an emergency for most of you, but unfortunately that's not the type of emergency that the TCPA really envisions as an exception to the rule for which you can make a call to a wireless call without consent. But basically, the TCPA provides that you cannot make a call using an automated telephone dialing system or a pre-recorded message to a cell phone or wireless device without the prior express consent of the called party. Again, a call via an automatic telephone dialing system or a pre-recorded message to a cell phone without prior express consent. On the landline side, it's slightly different. Landline side, it's a call using a pre-recorded message to a landline without prior express consent. And they use the word actually residential telephone. And we know that most residential telephone lines emanate from landlines. So again, on the landline side, it's only a pre-recorded message, the delivery of that triggers potential TCPA liability, meaning you could take your dialers and effectively dial a landline all day and not invoke the TCPA. You may invoke some other laws if you're calling all day, but you wouldn't be invoking the TCPA because it only regulates cell phones on the dialer side and cell phones on the pre-recorded message side, but on the landline side only pre-recorded messages trigger potential liability. Who does this affect?
Great overview, and I'm sure now as we go into these questions, we'll dig inside all those different topics and what some of that means. So, all right, this is actually a very good question. Are there any new updates since the release of the TCPA regulations about a year and a half ago?
Sure, and I just want to step back for a second and say with regard to this particular law, there is no general exclusion in the TCPA for any particular entity or organization or company or any particular trade group. It just doesn't work that way. Yes, there are certain exemptions that the FCC has provided. For example, the FCC has provided a commercial call exemption on the landline side, saying that if you're calling a landline using a pre-recorded message, and if it's just a call that does not provide an unsolicited advertisement or telemarketing, meaning you're not telemarketing or soliciting, then you have something called the commercial call exemption, and that exemption pretty much excludes any potential liability. So again, if you're calling a landline with a pre-recorded message and you're not upselling or telemarketing, then you basically you have an exemption. There is no exemption for the debt collection for the TCPA and the wireless side. There is no exemption for even nonprofit organizations. You still have to have prior express consent. On the telemarketing side, just remember, and when you're upselling or selling, you have to have prior express written consent. We're not going to get into that today because this is mostly focusing on collections, but we'll save that for a different day when we do the telemarketing side.
So David, let me just real quick, something you said this is interesting to me. Obviously, being in the sales side, we walk into a lot of different organizations. And one of the things you said is, make sure I understand that, so there is no exemption based on industry, like you said, on charitable contributions, things like that. That's still, from what I gather what you just said, the TCPA rules still apply, even if you're a nonprofit and it's a charitable organization. If you're dialing out, it still has to be consistent with TCPA. Is that correct?
Unfortunately, they do. There is no general exemption for any entity. In fact, what is really the most telling about this is that there is a move to make a change to the TCPA to exempt certain organizations, but and Obama's ready to sign that. But what it is an exemption for government entities collecting with respect to government debt. So, because even they are not outside of the purview of the TCPA. No one is. In fact, one judge recently commented, he goes, look, I know that the debt collection industry doesn't want to be part of this purview, but let's be frank, in 2008, the FCC issued a ruling saying, specifically addressing the collection industry and saying, no, we're not going to exempt you. We'll maybe give you these breaks, but we're not going to exempt you from the purview of the TCPA. And as the judge said, when in looking at the TCPA and in its writing, there is no general exemption for any entity in the TCPA is currently drafted.
Very interesting. Interesting. I didn't realize that as well, that the government is even currently not even allowed to dial for collecting. Interesting. All right. So the slide we have up now, any new updates since we kind of touched on that just a second ago, but are there any new updates since the release of the original TCPA regulation, which I believe was about a year and a half ago?
Boy, there's so many things have happened, so I'm going to try to give you the update in a succinct and summary fashion because I would need just an hour and a half to do that alone. Let's talk about what the FCC, so again, when you're talking about the TCPA, you need to have prior express consent, and you need to have that consent to call via automated dialing equipment or to leave pre-recorded messages on cell phones. Let's just concentrate on cell phones. So what is consent? In very short, the FCC said in 2008, consent is when someone says, here's my cell phone, go ahead and call me. You have permission to call me. You have permission to call me for any and all of my accounts. Go ahead and call me. Anything like that, that's an equivocal, unabashed expression of express consent. The FCC also said, look, collection agency, we're going to give you a break here. And if a collection agency is collecting on behalf of a creditor who has previously obtained prior express consent and can prove it, then you, debt collector, you stand in the shoes of the creditor once you're collecting, and there you too have that same prior express consent. Okay? That's the gift that the FCC says that they have given to the collection industry as a result of not exempting the collection industry from the purview of the TCPA. But this is what the FCC did just on June 30th. The FCC submitted an opinion, an amicus brief as they call it, in a case called NIGRO, N-I-G-R-O. And in that case, basically what the FCC is saying is as follows. Hey, we're looking at the issue of consent here in this case, and we just want to let you know what we mean by prior express consent. They think that prior express consent is narrow, that it must be interpreted very narrowly, and that the consent that you're given to call the number, you can only call that person for the reason that you are, quote, provided the number in the first place. And I'll give you an example. There's a case called Kolinek that just came down. And Kolinek previously, a couple months ago, said, oh, yes, you gave your number, Miss Kolinek, to Walgreens, and therefore they called you to tell you that you had a prescription that was ready, and you gave them consent, so sorry, you're out the door, and you have no claim here because you gave consent. You voluntarily gave your number to Walgreens, and they called you telling you prescription's ready, ergo, consent. The court went back on a motion for reconsideration and said, wait a second, we think we actually interpreted this too broadly, and basically consent must be construed very narrowly, and they actually issued this decision not knowing of the FCC's opinion in the NIGRO case. And they said, look, looking at the 2012 FCC order, the FCC says the consent is dependent on the context in which it is given. In this Walgreens case, the woman said, hey, here it is, you need my number. They said, oh, yes, we want to just have your phone number in our system to make sure that we don't confuse you with any other person in our system, and that's the way we tie our accounts. So she said, sure, here's my cell phone. They never told her, and we would be calling you on their cell phone and texting you to tell you when your prescriptions would be ready. There was no agreement, and the plaintiff says, I never provided the cell phone for that purpose. You would think that would be a natural part of giving your cell phone number to a pharmacy. But the court said, no, we've got to construe this broadly. She gave it only for the purposes of making sure that identification was proper with regard to the preparation of the prescription, not to tell her that a prescription was ready, and the court actually reversed its own decision and said, no consent. I know that sounds crazy to all of you on the phone. It is, but this is how far the FCC is going. So that way, when you get consent, make sure that you're using the consent that you get, that it's narrow, that it's focused. Yes, if the number is provided to a creditor in context with, let's say, a credit card, well then if there is a debt, that telephone number was given in context to opening that credit card, and of course that telephone number is given then during the transaction that gives rise ultimately to the debt. That's what the FCC said. As long as you're giving the credit card or giving your phone number voluntarily in connection with the transaction that gave rise to the debt in the first place, you're good to go. Someone gives you their cell phone to open up a credit card account, they incur a debt, the creditor can call on that number, the debt collector can also call standing in the shoes on behalf of the creditor to make that call to collect the debt using that cell phone number, and can use their auto-dialed equipment and can make pre-recorded messages and phone calls to that cell phone. Just make sure.
Okay, so then, okay, I'm sorry.
Go ahead.
David.
No,
I was just trying to
quickly.
Yes.
Go ahead, Ray.
Go ahead. No, what I was saying, this was Henry. What I was saying was, so as long as you've given consent, not just for identification, but actually to call, you can dial, both. You can provide pre-recorded announcements, messages, as you can also dial in a predictive or through a system using an automated algorithm. That's all okay now once you get consent. Is that correct?
That is true, and that's what the FCC said, and that's what certain decisions have also said. But just make sure that the consent you're getting, and the reason that you're calling, remember, it depends on the context in which the number is given in the first place. So make sure that the consent that you're given, and all of you probably on the phone are going to be calling in the context of debt collection or something concerning a debt or an obligation that relates to the creditor's account at issue. So as long as you're calling for that purpose, and the debtor has voluntarily or consumer has voluntarily provided a number in connection with the transaction that gave rise to the debt in the first place, you should be good to go. But remember, once you're getting consent to call someone, if you get consent to call them and you're calling on the GM account, just because this person may also have a Verizon account doesn't mean you can call them on that Verizon account unless they voluntarily gave their number to Verizon as well, or you got consent because they told you, yes, you may call me at this number for any and all purposes and for any and all accounts that I may have with your company that you're seeking to collect from me. Okay, so I'm just trying to explain. So if they say, yes, I'm calling you today on your GM account, do I have express consent to call you on your cell phone? Yes, you do. That does not mean you have express consent now to call them on their Verizon account, unless you said, do I have express consent to call you for any and all accounts we may have for you? Oh, yes, you do. No problem. It's the only phone number I have. Go ahead, call me. Then you've got to express consent. And ergo, capture that via a telephone recording, because then you have evidence of consent.
All right, perfect. Hey, Ray, I want to maybe bring you into this for a second. Is there anything you'd like to add, and something you've seen in the marketplace in the last year and a half since this thing really gotten visibility?
And I think David really outlines the complexity, because you have a lot of competing agencies issuing regulations that seem to confuse a lot of folks. David, I think one of the things that seems to be asked a lot, and we may get into it into the next question, but when you're talking about express consent, what about established business relationships? Can you kind of really lay out what express consent, especially in this narrow focus that you were talking about, and how that reflects on established business relationships that folks may have?
Sure. Let's just talk about in the context of The established business relationship was basically an exemption for on only the landline side. Remember, this is only on the landline side, this particular exemption. And it said if you have an established business relationship with someone, and that has a specific definition, and if you contacted that person via a pre-recorded message and they say, sorry, you didn't have consent to call me, you can rely on the established business relationship exemption because you had business dealings with them within the last 18 months, et cetera, et cetera, et cetera. Courts have had a lot of problems with that. And by the way, it was really only an exemption that was designed for the telemarketing industry because it's in the telemarketing section, basically, of the TCPA. Basically, all other industries were just borrowing that exemption. And in October 2013, the FCC said that exemption, that established business relationship exemption, it's gone. It's not gone on the fax side, but it is gone on, let's say, the calls to landlines with pre-recorded message side. So just forget about it for collection purposes. Don't even rely on it. Remember, you have the other exemption, which is the commercial call exemption for calls to landlines via pre-recorded messages where you don't use a solicitation or is not telemarketing.
Great. All right. Ray, you want to move on to the next question? I think we've made some nice progress on that one.
Yeah, one thing as we get into this question that I was hoping that David would also cover is the confusion around what an ATDS is, especially with the language around potential versus current capacity.
Great question, boy. This is one of those other questions of the hour, and it shifts from every court. I got to be honest with you, it does. And I literally mean from court to court, it's changing and expanding. And even when we think we have some great court language, from appellate courts that say, hey, this is what it means, you still have the lower level courts, the federal district courts, interpreting some of those decisions so broadly. And I'll give you a perfect example. So let's just talk about what is a dialer, right? This automatic dialer, at least under the TCPA, is equipment that has the capacity to store or produce numbers using a random or sequential number generator. Again, equipment, remember, it doesn't say a dialer. It says equipment, which has the capacity to store or produce numbers to be called using a random or sequential number generator. Then the FCC comes out and says, hey, guess what? We're going to interpret this ourselves. And we're going to say that, all those predictive dialers you're using, we're going to say that all those predictive dialers, they constitute a dialer. You know why? The bottom line is this. We're going to prohibit any equipment which has the capacity to dial numbers without human intervention. Again, the capacity to dial without human intervention, and the focus is on that word capacity. So the FCC has its rule. The statutory language has its rule. Some courts are saying, hey, forget about the statutory language. I'm just going to look at what the FCC says, the capacity to dial without human intervention. Do you have that kind of dialing equipment? Some courts are saying, boy, forget the FCC. The statutory definition in the TCPA statute itself, it's clear and unambiguous. Therefore, I don't think I can look at the FCC's ruling. I have to ignore it, and I'm just going to ignore it. And then some courts said, you know what? I'm not really sure what applies, so I'm going to look at the statutory definition for this case, and I'm going to look at the FCC's definition to see if this dialer at issue falls under either one of those definitions. So let's just talk about the statutory definition. You got to store or produce numbers to be called using a random or sequential number generator. It's great language. The problem is almost every court is rarely, I'm saying, interpreting the statutory dialer definition that strictly. I'll give you an example. One case called Gragg out of Washington. Gragg said, I'm going to look at the statutory definition and I'm going to look at the FCC definition. So under what happened there, it was a text message sent to the plaintiff in conjunction with a taxi order saying, oh, your taxi is going to be there in 5 minutes, that type of thing. You got a text. He said, I never gave you consent. And they said, well, you did, but even if you didn't, basically, we're not using automated dialing equipment because in order to launch this particular text, we have to plug the text into, and then a human being has to actually press and physically press a button to say, yes, launch this text. It cannot be launched in any regard by any means without that actual physical pressing. So the court said, okay, I guess the capacity to dial without human intervention, if we're looking at the FCC's definition, you didn't send a text that was called without human intervention. You had to have human intervention. The person had to press that button, or the text would just sit there like a dead dog. It wouldn't ever move and wouldn't transmit. And then he says, well, let's look at on the TCPA side. Gosh, the defendant has provided evidence saying they didn't have a random or sequential number generator in their dialing equipment, so ergo, guess what? You don't have a dialer. Well, let me just explain something very clearly. Many times there are good results in some of these cases, but if you look behind the man behind the curtain and find out what's really going on, and if you really read the case, it opens your eyes. And sometimes the plaintiff's attorneys don't do their job. It's great for the defense side, and we love that. It's great for all of you. But what I'm saying is the more sophisticated litigators know how to get around that statute and would not have let the court stop at that simple, using that plain language, using a random or sequential number generator. The court may have still looked at the strict language, but many courts are not. In fact, one court in California, looking at this issue twice now, in a case called Sherman versus Yahoo, said this: I see what the statute says. I see what the FCC says. I disagree with my brethren on that GRAG side because I've looked at everything and I looked at how that word capacity is to be dialed. So the court said this: I'm looking just at the statutory definition. Forget about the FCC's human intervention definition. Just looking at the statutory definition, I think that, and the court relied on a case called Satterfield from the Ninth Circuit, which we all thought was wonderful for us, and it is, but courts are interpreting it very broadly because of some loosey-goosey language in that case that gives them the folly to do so. This court said that, look, there is a disputed issue as to whether the system that Yahoo was using had the requisite capacity to both store numbers and dial random or sequential numbers. And the court said, we're only, not the fact that they did it, not the fact that it's designed to do it. He says, does the system have the potential capacity? So you're saying, how the hell is this word, excuse my language, the word capacity being interpreted? Some courts are interpreting it very narrowly, like the Hunt decision out of Alabama. They say, hey, capacity means present capacity. Other courts are saying capacity means potential capacity. When you're using the word potential capacity to both store numbers and dial them, if that's what they think this law says, if that's how they are interpreting just the statutory dialer definition, store and dial random and sequential numbers, well, guess what? You could almost have any equipment that does that. And I just want to add one more thing here. Another district court in Washington, D.C., not the GRAG decision, but another one, said this: you know, the plaintiff has stated that defendant is using its dialer in connection with Microsoft. Microsoft has Microsoft Excel, and through Excel, you can actually create a list of numbers, random and sequential, and you can generate them on an Excel spreadsheet. And then if you're using your dialer and you can use it in conjunction with that Excel spreadsheet, well, guess what? Your system now all of a sudden has the capacity to dial telephone numbers using a random or sequential number generator. So this court went that far, meaning that he looked at the equipment. He says, hey, if you're using this dialing equipment and you could marry it to your Microsoft equipment, well, that's part of the phrase equipment. In other words, they're interpreting the dialer definition so broadly that could bring almost anything into the fold. If I'm saying, hey, I'm using my, and I'm just giving an example, my Noble dialer, and I'm using it in conjunction with the Microsoft Excel, and yes, I guess I could create a random and sequential list of numbers. I could upload it and then dial that. Then in that court's view, I would have a dialer just under the statutory definition. Most courts are saying under the statutory definition, the system does not literally have to use a random or sequential number generator, just as long as all of the equipment in combination has the ability to either call a list of numbers that were randomly and sequentially generated. This is the problem with the dialer definition. It is being interpreted so ridiculously broadly in so many different courts. Yes, there are a few courts that do have a very narrow interpretation, but unfortunately, they are in the minority. And one other thing, and I'm sorry I've gone on so long, but this is so important, that the majority of federal courts in this country, when looking at the dialer definition, seem to be erring on the side of relying on the FCC's definition. And they even said, hey, the FCC said if you can upload a list of numbers and dial that automatically, if you have the capacity to do that with your equipment, not that you're doing it, but you have the capacity, then that constitutes potentially a dialer under the TCPA as well.
And you know, David, it's interesting because the questions that I get from my customers even go away from just looking at dialers, but having speed dial numbers stored on your PBX. There are ways, just the way these things are construed, that that even could be classified as an ATDS in certain cases.
Well, that's what that's what I love about that Gragg decision, and the reason why I keep on coming back to that. Yes, it's not binding really on anybody, as I just said. His brother in another court next door in the same state came up with a totally different opinion on interpretation. But the Gragg decision said this, and this is where we need to step back. You've got to use common sense when courts have to, when they're interpreting these dialer laws, or else you get insane results. I know with my handset Avaya phone that's sitting on my desk, standard phone that's been around for God knows how many, 20 years or so, I know that I could upload a bunch of numbers to that. They could be randomly, sequentially generated, those numbers. I could upload them then to my phone, and I know I could press a button and dial all of them. That would be, under some courts' interpretation, an automatic telephone dialing system, but that is where you start leading to an interpretation that leads to bizarre and absurd results. That's exactly what Gragg said you can't do in statutory interpretation, but that's what's happening, and that's the problem. Courts know about it, but they don't care. They're interpreting this very broadly. And then our friends over on the other side of the coin, on the plaintiff side, from the National Consumer Law Center on June 6, 2015, I'm sorry, on June 6, 2014, but I think it's very funny that they dated their letter wrong. They actually dated it June 6, 2015. This was a letter to the FCC Secretary Marlene Dortch, and they said, hey, look, we're seeing all these petitions that have been filed, and we're going to weigh in here and tell you what we think. And this is what they said in short. They think predictive dialers are dialers and they're harmful to wireless consumers. They think that the current definition of the auto dialer, meaning the TCPAs, is still appropriate. And the reason why they said that is because they like how now the courts are interpreting even the statutory definition in the TCPA because they're interpreting it so broadly. So in other words, they're thinking, gosh, we got you under the FCC definition. We probably get you under the TCPA's definition. We're good to go. They also say that, oh yes, the entire industry, all the industry is complaining that the sky is falling from these TCPA claims. Sorry, it's because of the way you all are using your automated dialer equipment. They talk about consumers need to be protected, and they talk about what would be the negative impact upon consumers and their cell phone usage if there is a change in the definition of the auto dialers.
I have a question. When we were going through this, one of the things we were going through this, we talked last time a lot about, Santander, versus Nelson, and I know that one of the things that we've heard, and one of the questions that we got, was there was a discussion about that ruling was vacated, and I'm not sure. The question really regards, well, what does that mean? What does the Nelson versus Santander that it being vacated now mean?
Sure, I can probably do this and sum this up for all of you on the phone in 30 seconds because we have a lot more to get to. But in short, and I've given you, just between consent and the auto dialer side, we've given you a lot so far, but there's a lot more to talk about. Very quickly, Santander was a decision where the defendant said, hey, look, I'm using my dialer, but I'm using my dialer in preview mode. So, because I'm using it in preview mode, I'm using human intervention. So that's what the FCC said. So guess what? I'm following what they said. I'm good to go, aren't I? And the court said this, sorry, that's just a red herring, this preview dialing, because I'm going to look behind the curtain. The issue is capacity. It's not what you did. It's what your dialer has the capacity of doing. And you use the so-and-so dialer, and that so-and-so dialer has the capacity to dial automated numbers. You just didn't use it in that mode on that given day, and I'll give you credit there, but sorry, it doesn't get you anywhere because court says I'm stuck with the word capacity. It's not me. It's in the statutory definition from the TCPA, and it's on the FCC side. Both of those definitions use the word capacity. That's the problem. Santander's a vacated decision, which is good, meaning it doesn't have really any precedential value. It didn't anyway. But the fact is it's still out there, and other courts are interpreting dialers in the same way. They're basically saying, okay, you have an automated dialer, but you use it in, quote, pure manual mode. I get it, and that's lovely. But the problem is you used a dialer which still has the, quotes, capacity to dial without human intervention, or a capacity to upload a list and dial it automatically, the capacity to potentially store numbers and dial random sequential numbers if they're uploaded to your system. So either on that TCPA side or either on that FCC side, you have a dialer because of that word capacity.
Plus, you know, when you think about it, David, even though the ruling had been vacated, it didn't stop the rules that were released on October 16th last year. Those are still in effect.
Yes, well, the October 16th rules, again, are to the telemarketing industry, and that requires written consent, and luckily they didn't get into the whole dialer issue, but the dialer rules still apply.
And look at the next question we had. You just went through it, so I think we're cool with this one, unless you have anything else you want to add. You just explained, it doesn't mean the dialing in preview versus manual mode. Obviously, you just said it. It's not compliant as long as the equipment has the capacity. So I think
it's very risky. It is. I mean, look, you may have an outlier court there that may say, oh, well, you dialed in preview mode, so at that moment, if I'm looking at present capacity, you didn't have the present capacity to dial in an automated fashion because you literally used it in preview mode, but very few courts, unfortunately, very, very few, are interpreting, again, either the word capacity in that manner. They're interpreting it broadly.
Okay, so Ray, let's move it forward. So, keeping all that stuff in mind, now I think we're going to kind of go into some of the best practices here, some of the questions that we got from our customers. So are there any specific rules around using automated dialers and automated messaging that we should be aware of? I know it's relatively vague, but maybe you can kind of take a point or two on this, David, and
Sure. Again, because of the state of the law right now, and I'm sorry, I wish I could give you better news, and and I'm going to talk a little bit about what the FCC may do, because I've met personally with the FCC in a private meeting with various collection agency representatives to talk about the law in particular context. And I got a feel for what's going on and what they're going to do. And we've spoken to the FCC commissioner, one of the commissioners, there's 6 of them, Commissioner O'Reilly, who is the conservative commissioner on the FCC side. And he thinks the law is crazy and he thinks it's nonsense and he really wants change. The question is, can he really do anything? And he speaks these lovely platitudes, and I commend him. The question is, can he really do anything with the current climate? And he says these nice platitudes, but is that going to translate to a change in the FCC's interpretation or in the Congress's interpretation? Remember, the FCC can't touch Congress's interpretation of a dialer. Yes, they can maybe enact an exemption for a particular industry, but they've got to be very careful doing that. So with the current climate right now, and if you're going to use a dialer which has the capacity, let's just say, to upload numbers and dial automatically once you upload those numbers, if it has the capacity to do that, not that you're using it, but that it has the capacity. I don't care if you're using it. Then what you must do is, before you call a cell phone, please make sure that you have prior express consent to call it. And if you don't, manually dial that number. And I'm not talking about manually dial through a dialer that has an automated process. Literally manually dial that.
And I just wanted to highlight, David, from a Noble perspective, based on that understanding, when we created or developed our TCPA solution ourselves, we looked at segregating those processes off of the dialer and more onto a manual type of dialing situation, where we actually take the entire call process off the dialer. We don't upload any types of numbers onto there and require the calls to be outpulsed through a manual mechanism.
And that's what you have to do in this climate. Is there anything that's foolproof? Boy, I haven't seen it. I mean, look, the TCPA basically does not regulate manually dialed calls. The word manually dialed call is now itself being interpreted in various different ways. But let me just make it very simple. If you are picking up a standard Avaya handset and that call is going through, let's say, a standard PBX out to the networks, I can pretty much say that between 75 and 95%, I can argue that and win that you weren't using a dialer under the TCPA, and a plaintiff attorney would be a fool for bringing that type of action against you. But if you're using anything else, it's at least fair game. Yes, the plaintiff counsel, they think that the law is so broad that they can almost bring anything and everything into the fold, and that's what they want to do. So they're going to sue you on everything and everything. I'm sorry, that's just the climate we're in. But, and they know, look, if they're targeting a fairly large company, they know that most companies are not going to have 3,000 employees making manually dialed calls through telephone handsets. They know they're using automated equipment of some kind, and they want to challenge that.
Even one thing to point out is that even in a manual setting, we've had customers that have said, well, I'll just do click to call, where they just click on the number they want to call from the agent's desktop and think that that they're within compliance there. But from what we're understanding or seeing, there's still a risk involved there when you even just clicking on a number instead of just going ahead and typing the number in manually.
Right. So let's talk about the click-to-call issue. There is nothing that literally says, either the FCC that I've seen or that I've seen in the interpretation of the statutory definition of a dialer under the TCPA, that says you literally have to type in all 10 digits. Yes, the Santander case sort of said that in loosey-goosey language. They said, well, gosh, you clicked the dial and you didn't even type in all the 10 digits. But that was only a loosey-goosey part of his entire decision, and he really didn't say the law requires that, and he didn't cite to anything. And he was just sort of rambling at that point in his decision. Again, that decision is vacated. And there's nothing that I've seen that says that you literally have to dial that. I think it's all about the capacity to dial without human intervention. So if you're using, a dialing mechanism that does not have that capacity to dial without human intervention, that if you've disabled the automated function from it, if it is incapacitated, then I think you have a very good chance of making a good argument that you're not using a dialer. I don't care if you're clicking to dial, that's not the key, or typing in all 10 digits, because there's really no difference. It's about how is that call being dialed. Is it being dialed with automated equipment, or is it is it equipment that has the capacity to dial without human intervention? If you've got to have a human, and there's no way you could call except by either punching in those numbers or a click, I still think that's the human element that stops the automated processes. And I think that's key.
Okay. I like about this is we've been pretty consistent. I think that's exactly consistent. And I know we're down to about 15 minutes here, so why don't we jump a few. Ray, why don't you jump to a couple of slides forward. I'm going to take a little literary license here, do a little bit of editing on the fly. Why don't you jump to, I think it's slide 10. Keep going. One more. Yeah, why don't we talk about this for a second? What is the best wireless opt-in verbiage required for express written consent? And what is the best way to get customers to give permission to calls if they've got over, almost 500,000 members? I'm curious how you what you see other clients doing, what you think makes sense?
Yeah, and I think this question is focused on the telemarketing side, and I know that our focus was a little different today, but in very short, under the October 16, 2013 new TCPA rules, which govern basically the teleservices industry, you need express prior written consent in order to make a call to a cell phone where you are going to be telemarketing or upselling or selling something. So that is required. There is a question right now that it's out to the FCC pursuant to a petition, and what it says is this: look, if we've already gotten prior express consent and we already had this established business relationship, and we already have all these numbers in our data bank, and we already had prior express consent to call these people under the old rules, please grandfather all of those in, because for us to try to get express written consent anew for all of our members for which we had consent under the old rules, under the old guidance, is absolutely insane and is killing industry. To tell you the truth, I don't understand how the FCC could rule differently, because it would be so unfair to the teleservices industry. I mean, right now the rules for the teleservices industry, the only way to get consent, there is no oral consent. Remember, if any entity is in the, let's say, non-telemarketing, non-solicitation sector, and you're just providing information, or you're in debt collection, or you're giving just an informational call, then you just need to get what is called regular consent via oral or written means, okay? So that is the way. Now just remember, with oral, if someone tells you on the telephone, that's fine, and you capture it, you write it in your account notes, whatever those would be, or the account, you're good to go. But then someone could always challenge that. You know, you need evidence, and evidence could be a recording. But let's talk about the written consent very quickly. You know, to get customers to give permission to call their cell phones when you have over 450,000 members, and if you have to get that anew, and I understand it's draconian. You can get express consent in the written context in various different ways. You can get it from the e-sign act. You can get it from a recording. You can get it. They can press certain buttons on a recording after they hear certain disclosures, and they could say, yes, I opt into this. You can do it on a website. That's one of the best ways to do it, because they've read the language, they've checked the box, and all of the required disclosures for obtaining written consent would presumably be in there. You just can't get it on the phone by saying, hi, do we have your express consent? Sure you do. If you're going to do it through the e-sign act, meaning verbally or orally, there's got to be certain parameters that have to be followed. So it's
David,
very difficult.
I'm sorry. What I was going to say is that I know we're talking about telemarketing, but would that work for the collections world as well? If you have an organization that obviously they maybe aren't collecting now, but as you get into the business relationship, whether it's, you know, financing a product or service or whatnot, as you know, somewhere in that process, could you do the same sort of opt-in, you know, whether it's on the website or, you know, e-signature or something like that, and use it for both telemarketing and collections?
Sure, you could, because if let's just say if your consent is good enough for telemarketing, it absolutely is good enough for informational or collection calls, because it's a higher level of a consent. It's a higher standard. And
David, one other thing around consent, yeah. I apologize for interrupting there.
No, go ahead.
Is express written consent transferable, whether you're an agency that assumes a portfolio or you're a financial services group that purchases a portfolio where consent was already there? Is that something that transfers, or does the new organization have to get that consent all over again?
That's an excellent question, and it is one that, gosh, so many companies wrestle with. So the question is, look, if I have I'm just going to give an example here. AT&T sells a book of its older business or whatever it is, and it sells it to someone and says, here, you're being sold. This is assigned to you now. You have a contract. You assume all of our rights. So if the AT&T customer provided their number to AT&T in connection with the transaction that gave rise to the debt, meaning they did it in the contract, well, the person who is the assignee who is buying, let's say, the portfolio is then getting all of the, I'm sorry, there's some background noise. I apologize. I'll say that again because I don't know if the people heard me. That if you're assigning the debt, if you're buying the debt, if you're buying a portfolio, then in most contracts you would assume any and all rights that the seller had. If you're assuming any and all rights, many courts, not all, but many courts will recognize that you have purchased the same rights, duties, and obligations, and therefore if someone gave consent and you purchased that consent, well then you've got it. If someone on the phone orally gave to AT&T directly their consent to call them on the cell phone, is that consent going to transfer over when you get the account? Maybe, but maybe not. That's a tougher call. Some courts will say, sorry, that's not express consent. They gave express consent to AT&T, not to its assignee. They may have, when they signed their original terms and conditions, and there may have been very good and broad language in the terms and conditions from AT&T that said, hey, you give us consent when you give us your number, and you give it to anybody who's collecting on your behalf, and you give it to anyone who may buy or to whom we may assign your account or your portfolio. So
right.
it depends on the language.
I think we got room for one more question. I think, Ray, you've got one more you wanted to move to. So why don't we go to this one last question before we kind of wrap it up? We're getting like less than 10 minutes here to go.
Sorry, I'm on the wrong one here. There you go.
Here, so David, I know we're on the line today. We've got several agency clients. So are there any specific steps that agencies should take when contacting for collection purposes?
Yes, when you're contacting for collection purposes, make sure if you're calling a cell phone that you've used scrubbing technology to scrub out and weed out which ones are your cells and which ones are not. Don't assume that just because your client gives you the number or that the number came over from the client electronically that you have expressed consent. Unfortunately, the FCC said, hey, if we're giving you, collection industry, this gift where we're saying that if your creditor has consent, you have it as well when you step into their shoes and you collect on their behalf, don't assume that you've automatically got consent because you're going to have to prove it. Well, how would you prove it? Oh, hi, here's the application, the original application, and you wrote down your number, and that's the number that I called, so ergo, I had consent. That's good evidence in support of consent. But you cannot assume that you automatically have consent just because your client may have electronically transmitted a phone number to you for the purposes of collecting a particular debt. The reason, because you never know from whence the creditor got the number in the first place, and that's the key and that's the trick.
So is this around cases where you have customers who put their cell phone number in their home number field, or when you talk about number portability where a cell phone number is transferred to someone else? Is that what you're talking about?
No, but let me touch on that for a minute because that's an excellent point. So that's very good. Let me step back for a second. So if someone, let's say, puts their number on an application, it's their cell phone, they put it in the home field, that's still voluntarily giving the number. You may think it's a landline, but if you've scrubbed it, you're going to know it's a cell. Doesn't matter if they put it in any field. If they've given that number voluntarily in connection with the transaction that gave rise to the debt in the first place, then you have the right to call them. Okay? So you just need, the problem is this proof. You know, the FCC says, sorry, creditors, you're going to be responsible if your debt collector called on your behalf, and you debt collectors, you're going to be responsible as well. So that's the problem. The FCC is imposing this liability on both entities when one entity makes the call. So if the debt collector makes the call and there was no consent, the person can technically sue the creditor and the debt collector. The interesting thing is not many of the plaintiffs' bar are suing both the creditor and the debt collector at the same time. They don't want to muck up their case, or, you know, they don't want to add more work to themselves in that context. They want to make it simple and clean.
So, David, to make sure I understand this, because I get this question a lot. So if our clients will ask me, okay, so in my application, they put their home number down, or the landline down, and they actually put their cell number in it. that does not negate a customer's responsibility, meaning if I'm the collection agency, I still have to go do a scrub through one of the, when we use a firm, and we can give our clients as a referral to do that, to go scrub it and check landlines versus cell phones. But what you're saying is just because a person put a cell phone in the landline number, that does not give you the right to call that without liability potentially. Is that what you're saying?
And I'll clarify. Just if someone puts their number on an application, let's say a credit card application, and they voluntarily put their number down and they put it in the home field instead of a cell phone field, it's still the voluntary providing of that number. So if you're calling in connection with that debt and they voluntarily provided their number on the application, I don't care where they provided it, you're probably good to go. Just because they put it in the home field, it doesn't matter. It's a cell phone. It's the voluntary providing of the number which is the crux, not where they put it or how they designated it. And unless they say, here's my number, but don't ever call me on that, unless they tell you that, you have the right to call it in connection with, quote, the debt, in connection with that credit card bill.
All right. So Ray, why don't you move to the last slide, please? And yeah. So I guess we're running out of time. As like I said earlier, we're going to post this on the website here in a few days once we do a little bit of editing. But at the same time, I wanted to give everyone David's contact information, and David was so kind to, and we'll also, by the way, the questions we didn't get to, we will put those up on the website as well. David is kind enough that if you see his contact information here, if you do have some additional questions, please you can email him directly, and he will get back with you guys. So I think that's all I've got for everyone. I appreciate everyone who joined. David and Ray, thank you both very much for being our guests today. You provided a lot of great insight, and as we talked about last year, and I'm sure we'll continue to talk about it keeps changing, but which is the reason we keep doing this. We got to keep on top of it, and as changes happen, we got to make sure we know what's going on and moving forward. So thank you very much, everyone, and look forward to seeing you on the next session in a few weeks. Bye-bye.
Thank you, everyone, and a pleasure dealing with all of you.